Able to make sure to get everybody out of here and enjoy this beautiful day after, this is our last 90 bills in 90 minutes, and then we have lunch, a presentation from Chief Justice Courage, and a legislative panel. So we still have a lot on the docket today, but we're running on time, and I'm really pleased about that. Our last, but definitely not least speaker is Rachel L. Bassett-Simcoe.
Yeah.
Rachel is leader of the Bassett Legal Group, and she's been a trial practicing attorney since 2003. Her and her team were very involved in challenging the emergency rules passed by the Department of Health in July 2018. This Bassett Legal Group is one of the only law firms in Oklahoma that will be able to provide services in all aspects of medical cannabis industry in Oklahoma, including civil litigation, business law, employment, criminal, family, personal injury, bankruptcy, social security, and tribal matters. So I've had some people ask me questions about cannabis law that I can't answer, and I think Rachel is your gal who can do all that. She's licensed to practice in all Oklahoma courts, 10th Circuit, Chickasaw Nation, and the state of Missouri. She's a mother of 4 and also 3 fur kids.
Yep.
So please help me in welcoming Rachel.
Good afternoon. If you've been following along, Oklahoma made some history in June 2018 when State Question 788 was passed. It's the only state question in Oklahoma that has been passed without any major political backing with it. State Question 788 created 7 statutes, and it really set the state of Oklahoma on its head. There was lots going on at the legislature in the summer of 2018 while they tried to figure out how to implement this legislation. In the 2019 legislative session, we saw something like 60 bills proposed, with 6 that had getting passed and implemented everything. House Bill 2612, which is commonly referred to as the Unity Bill, was the big piece of legislation that came out of last session. And it's interesting to note because State Question 788 was written by individuals. There was not lawyers involved with doing it. It was completely activist based. And State Question 788, as it was passed, did not create an act like we're typically used to seeing in legislation, didn't have a lot of enabling language, that sort of thing. And that's what caused the frenzy. And so last legislative session, when House Bill 2612 was passed, it actually created an act in our usage and terms of seeing legislation. But what they didn't do, I think in part because they were afraid of the political fallback, was overrule or get rid of the 7 statutes created by 788. And so now we have 2 sets of legislation that parallel each other but contradict each other in many ways. And so a lot of what's happening in this legislative session is getting those 2 sets of bills in line with one another and clearing them all up, as well as cleaning things up. We've seen 55 bills impacting medical cannabis this session being presented, 21 of which I think are really important. I've included everything in these slides for you to look at, and I'm going to go over them as fast as I can. Significantly, most of them are cleaning up 2612. The first one is House Bill 3956, which eliminates the 2-year residency requirement for a transport agent license. Last session, they created the equivalent of a CDL for those who are transporting cannabis, and it required that you have a 2-year residency requirement. 2612 also instituted a 2-year residency requirement for owners of medical cannabis businesses based upon a decision that came out of the Supreme Court of the United States this summer, the Tennessee Valley Wine and Spirits case. I believe the 2-year residency requirement on cannabis business owners is unconstitutional, and that is actually something my firm is looking at challenging on behalf of cannabis businesses. But House Bill 3956 removes the 2-year residency requirement on transport agents because anybody who's transporting must have a transport agent, including the owners of those businesses, and that has created a hardship. House Bill 3256 adds a requirement that transport companies carry a minimum of $350,000 in auto insurance. that hadn't been stated anywhere previously. They tried to pass that in the rules that were done in the summer of 18. 3956 out of the House removes the requirement that there be GPS tracking in the vehicle. They had added through 2612 last year that transport vehicles had to have some sort of GPS tracking in it. They said it couldn't be on your phone, but they didn't specify how that was going to have to be. That's something that's been difficult in implementation this year. House Bill 3954 does several things that came out of 2612. It removes the opaque packaging requirements on the piece as it's sold on the shelf. That was created in 2612 last year, and makes it a requirement that as the packaging leaves the store, it be contained in opaque packaging. In the cannabis world, that's typically an exit bag, which is a giant Ziploc bag that is opaque. So the products that go inside of it, as of last session, had to be in opaque packaging, prohibiting consumers from seeing the quality of the flower that they were purchasing, the quality of the cartridges that they're purchasing, because you can look at the color of distillate and it can sometimes indicate, if you're buying a vaping product, the quality of that product as well as the edibles, etc. It also excuse me, clarifies requirements on measuring 1,000 feet from the school, and removes the really cumbersome requirement that renewing businesses have had this year of their certificate of compliance. So 3954 is a big bill. 3974 limits the number of licenses for waste businesses that were created in the last session. Initially, it created only 10 of those bills. If you aren't in an area where you can compost or burn your waste, then you have to use a medical waste company. And so there were only 10 permitted bills 10 permitted licenses last session, but that eliminates it. 1512 gets 2612 and the 788 statutes in congruency on the 90-day approval timeline. Interestingly, it also increases the application fee from $2,500, which is the cheapest in the nation, to $10,000. I think the hope of that is that's going to eliminate the amount of businesses that are popping up. People are really objecting to the idea of limiting the number of licenses. So the way they're limiting licenses is making it a little bit harder to get them, as well as increasing license fees. House Bill 2779 impacts employee protections. I'm not sure if it's that one. I have to go back. Let me see. It's actually House Bill 3256, which also impacts employee protections. House Bill 3256 is very important to watch because Section 3 of that bill actually repeals all of Section 6 of 788, which is 63 OS 425. 63 OS 425 has all of the individual protections for Oklahomans. It prohibits discrimination based upon being a renter with a card. It eliminates employment rights, gun rights. It eliminates protections on custody and visitation, which if you're a family law lawyer has been a huge issue in the last year and a half. It also eliminates the ability to not zone them out and eliminates research license protections. I also think that House Bill 3256, along with other bills, violates the single subject rules, because we have several bills that are trying to limit things happening with the ABLE Commission mixed in with cannabis, and based on the recent opinions coming out of the legislature, or excuse me, out of the Supreme Court, that violates single subject. Senate Bill 1909 helps do away with a lawsuit that's currently pending. Last legislative session, they passed in 2612 provisions that allows law enforcement to get information about license holders, with the idea being that if somebody is stopped and they have marijuana on them, they can verify the validity of the license, and that should be the only thing that they can do. But it was written so broadly that it was felt law enforcement would be able to search anybody and determine whether or not they had the card. So Senate Bill 1909 clears that up, says that there shall be no information sharing with Law enforcement, if an individual has a card, law enforcement or anyone, an employer, upon presentation, can go to the OMA website and check the validity of that card, and that is really all that is needed to do. There's no reason why law enforcement should have access to that, or anyone should have access to that, in my opinion. Another bill that's very important that needs to be watched is proposed by Representative Fettgetter. It's House Bill 3959. It actually creates a standalone agency. OMA would be taken out from the Department of Health and moved into its own separate agency. That's a really big deal. House Bill 3954 will recognize out-of-state cards. There will be no reason for individuals coming to Oklahoma having to plan 30 days or more in advance to get a temporary card. They'll be able to go into our dispensaries and purchase if they're a medical patient. 1245 adds child care centers as a limitation on location for dispensaries. Right now we're only 1,000 feet from the school, but House Bill 1245 will add that to daycare centers as well. And House Bill 3957 will allow dispensaries to grind and roll their own pre-rolled joints. That has been a dispute this last session over whether or not they had to have a processing license. Thank you so much. If you have any questions, I'll be happy to talk to you individually.